But just one brief point. As Dave Graham said in this morning's panel, the war on terror is unlike past wars. And that certainly is true. And one of the ways in which it is different, and I think perhaps unique, is in the importance of intelligence gathering. And most wars, intelligence gathering is an important function because in order to destroy the enemy's infantry, their warships, and other assets, you must first locate them. And if you can determine their plans when they plan to attack, you can ambush or do other things to make their lives more difficult. But the decisive factor ultimately is your military power versus their military power. They've got aircraft carriers, you've got aircraft carriers, they've got battleships, they've got tanks, they've got infantry divisions, and so forth. And no matter how good your intelligence, if your military force is not good enough, you're probably not going to win the war. Unlike in past wars, in the current conflict, the single most important factor by far is intelligence. You have to locate the enemy and discover their intentions if you're to stop their terrorist attacks. If you succeed in doing that, you could probably achieve the military objective of apprehending or killing them with a good police force. We're not talking about a military force that has tanks and fighter aircraft and bombers and so forth. It's a relatively small number of fanatical people that are willing to blow themselves up to kill Americans. And the most important single function here is the intelligence function. In most wars, enemy soldiers, when they're taken prisoner of war, when they have the misfortune of falling into the enemy's hands, they become effectively irrelevant to the outcome of the conflict. Today, when we capture a senior al-Qaeda operative, the knowledge he possesses may be critically important to our ability to prevent the next 9/11. I mention this because I think it's important to understand that the people who made the bad decisions that I think everyone in this room agrees were horribly bad decisions, were not evil people. That's not to say that some of the things that were done as a result of their decisions were not evil things. But they were people, they were patriotic Americans, they were honorable people in most respects who were trying hard to stop the next 9/11. And they were making decisions in the aftermath of the worst attack on U.S. territory since the Civil War. They thought that if they didn't act quickly, if they didn't get intelligence, that thousands of American lives might be at stake. And I think it's possible to understand how they did this balancing without agreeing that they made the right choices or without in any way trying to justify what they did. Now let me start with some questions for the panelists. I've been asked we need to be interactive here, so I needed to come up with some good questions here, and not being nearly as much an expert on this topic as the three gentlemen to my left, I asked them, give me some questions, guys, and I won't blame them for the questions, but at least the seed for each question comes from one of them. And I want to start with David Graham. David, can you briefly summarize the existing international norms concerning the detention and interrogation of foreigners during times of armed conflict, and also contrast that with the regimes embodied in the United States law to the extent there are noteworthy differences? And after David, if Sean or Joe, if either one of you have any, especially any differences, you'll have an opportunity to join in. David?
Okay, Bob, let me take about 10 seconds to say how pleased I was to be introduced by Professor Ron Griffin. Professor Ron Griffin and I served as very young JAG captains at the JAG School back in 1972 and 1973. And we were told that we would teach an elective, which was a mandatory elective. You get accustomed to those things in the military, to our graduate program entitled Race Relations and Military Justice. And that was an interesting experience, I can assure you, back in 1972 and 1973. In terms of international norms that apply to detainees, and I would emphasize that detainees is sometimes used as a generic term to capture all the people who have been taken prisoner by U.S. forces, but detainees is defined characteristically and individually as a separate category of detainees. You have POWs, you have interned persons, but all the regulations and FMs refer to detainees as a separate category of individuals who have been captured. I could talk to you about the 49 Geneva Conventions, specifically the Third Convention and the Fourth Convention that deals with the protection of civilians in time of war, as well as the Third Convention that deals with POW. I could talk to you about the International Covenant on Civil and Political Rights, I could talk to you about the Human Rights Convention. I can talk to you about Common Article 3 of the 49 Geneva Conventions, which is considered to be the minimal standards to be afforded any individual captured in a conflict as customary international law and law of war. And as Professor O'Connell mentioned earlier on in the day, I can talk to you about Article 75 of Additional Protocol 1 of the 49 Geneva Conventions, which has long been considered by the United States, contrary to what some individuals have indicated, as customary international law and binding on the United States. But the most important point that I would like to make is that all those international norms were captured in something that we refer to as Army Regulation 190-8 that deals with the treatment of detainees, and Field Manual 34-52 that deals with the interrogation of detainees. That's been superseded subsequently by Field Manual 2-22.3. And I can tell you that all those international norms were reflected in that regulation, in that field manual, because my office conducted the legal review of it back in 1992, a very extensive legal review. So that at the time of 9/11, there was a well-established legal regime with respect to the treatment and interrogation of detainees, to include detainees who may have been designated as unlawful enemy combatants. We knew what we could do. We knew what we should not do. So when Bob says, can you talk about the variances in terms of U.S. standards and what the international standards were, let me leave you with the very firm conviction that as of 9/11, with respect to detainees, there was one standard, and that was the standard that was captured in AR 190-8 and 3452, and it fully reflected the requirements of international law.
Okay. Could you briefly summarize? So we're talking about humane treatment. Is that the basic standard, or?
Well, I think humane treatment obviously is captured in the Third Convention. It's captured in the Fourth Convention. It's captured in Common Article 3. And I'll speak a little bit later on if the situation presents itself to the importance of Article 3.1c, which is the article which prohibits outrages against personal dignity and particularly humiliating and degrading treatment. And I just emphasize here that when people focus on does something or does something not constitute torture, that's not really the issue. It's not really the issue. The issue is that you don't have to have an interrogation technique that rises to the level of torture to violate international law and the law of war. The standard is Article 3.1c. The Common Article 3.1c of the 49 Geneva Conventions, which specifically prohibits, as I just indicated, outrages against personal dignity and humiliating and degrading treatment. So that's really what we need to focus on. So when someone says, well, it doesn't rise to the level of torture, which is exactly what the torture memo that Justice produced in 2002 said. There are a lot of things that don't constitute torture that may constitute CID, or cruel, inhumane, and degrading treatment. But the issue is that if it does constitute CID, it is nevertheless a violation of international law. So let's focus on that as the standard as opposed to whether something does or does not rise to the level of torture. And in those terms, Bob, I think as I indicated, when 9/11 occurred, the treatment standard for detainees was you will not violate Article 3.1c. You will not engage not only in torture, which was an absolute given, but you will not engage in treatment and interrogation techniques that constitute a violation of Article 3.1c.